working collaboratively to help our 99 municipalities. So today, we're going to discuss ethics and conflicts of interest. And as a municipal officer or employee, it's your job by its nature, and it places you in a position of public trust. You are responsible for ensuring that public resources are used in the best interest of the public, and you also have a duty to conserve and efficiently use those resources. When serving in your public capacity, the interests of your municipality must come before your own. In face, in appearance, your actions, interests, those of your municipality must come before your own at all costs, at all times. And this training is intended to help you better understand conflicts of interest and ethics for municipal officers and the responsibilities when your public or private interests conflict. This is a training. It does not substitute for legal advice, nor does it mention every aspect of the law that may apply in a particular situation. Municipal officers and employees should contact their legal counsel about conflicts of law and ethics and receive individual case-specific advice. Now that I've provided that information to you, the conduct of local governments and officials and public officials affects public perceptions of the trust in the government. Citizens expect local officials and public employees to act in the best interest of the government and the public, and not to use their office for their own personal benefit. In some cases, laws restrict conduct of public officials, but in many cases, they have a choice in how they act. For example, when deciding whom to hire, when to contract, and how to vote. Constitutional due process requirements focus on the need for fair and unbiased decision-making when certain types of private rights are at stake. So we turn to the big issue of what is ethics? Now, the word ethics can cause some of you to immediately slump over in immediate boredom. Others find it completely fascinating and they can talk about it for hours. But the majority of us are somewhere in the middle. Our understanding is that it's relevant, it's important, it applies to all facets of our lives. However, we don't seem to dwell on it endlessly. The best approach that I can share with you is the duck analogy. If it waddles like a duck, quacks like a duck, swims like a duck, it must be a duck. So it follows if something looks unethical, sounds unethical, appears unethical, it's probably unethical. In terms of attorneys, the unethical behavior simply does not pass the smell test. Many of you may be familiar with the smell test. So turning to ethics, what is ethics? Ethics is one's moral stance. When someone asks you, what are your ethics? They typically mean, what are your moral principles? What kind of a person are you? Are you good? Are you bad? Do you live up to your moral principles? There is a standard list of morals or principles that each culture adheres to. And in order for you to understand today, please understand it's not tricky. The tricky part of ethics is the moral concepts like good or bad, because they're subjective in nature. Therein lies the problem. Ethics is the study of the good as in what's truly morally good or what's truly morally bad. Victorious or evil, good, bad. One's ethics are akin to their morals, their rules, their guidelines, and how people choose to live their lives. Morality is not actually different from ethics at all. One has morality if one has ethics, because what's good is, in all senses, is integral to both. Now, how does a municipality establish standards? Well, essentially, there are three standards or three basic understandings of guiding principles for you to understand. There's the legal standard, the ethical standard, and the moral standard. It helps to understand it in this manner. If the law tells you what you should not do, ethics tells you what you should do, and morals tell you what you should aspire to. Doing what is legal is the minimum standard for public officials. It provides the outer boundaries of conduct, what you can and can't do. Setting ethical behavior standards for everyone who works within the organization is very, very important. There is a difference between legal and moral, legal and ethical. And if an attorney says it's okay, it still may be unethical. And that's an important distinction for you to understand. You may ask yourself, am I legally permitted to do this action? Within the law, you may be legally permitted to do that action. But the next question should be, is this something ethically that I should do? And then finally, is this something morally that I can, a decision or a situation that I can live with? Ethics are a little bit more difficult to understand. It's really driven by the individual. It can be driven by the organization. If you have a great leader that's positive, that's very ethical, that's very morally based, those underneath him typically seem to fall and follow in that line. The true can be said if you have a leader that is not as positive or ethical in their nature. So it's not enough to simply refer to the state statutes, local ordinances, policies and procedures. As a municipality, we should be looking at developing our own professional codes of conduct, our own what we believe and how our community should run and how our city should run. And I did a quick search for Code of Ethics, and I was able to locate an amendment to the City of Casper Code of Ethics, September 16th of last year. I've reviewed the ethics Code of Ethics that they have adopted, and it would be a great draft if you're interested in your municipality in drafting a Code of Ethics. They even have their ordinance online. So that's something that you should definitely look into moving forward. Now turning to the crux of the discussion today, which is conflicts of interest. Why is it important to address conflicts of interest? In addition to the statutory requirements previously mentioned, there are also political, legal, and reputational interests at stake. Failure to manage ethical dilemmas appropriately can significantly damage the reputation of a local official, an entire public governing body, or the municipality as a whole. Within the context of local government, a perceived conflict of interest can be just as problematic as a real conflict of interest. The Wyoming legislature has provided us enabling authority to create and adopt conflict of interest provisions for resolving local conflict of interest. It is therefore up to each individual municipality to articulate standards for identifying and managing conflict of interest that are as restrictive or more restrictive as the state statutes. Now, the structure of local government, the breadth of local government's responsibilities is to decrease whenever possible the likelihood of allegations of conflicts of interest that will be leveled against even the most conscientious municipal officer. A municipal conflict of interest policy can help guide elected and appointed officials through situations that present actual or perceived conflicts of interest. The adoption of a conflict of interest policy sets shared expectations about how conflicts and perceived conflicts will be handled by municipal officials. Now that we've discussed why it's important to address conflicts of interest, let's turn to what is a conflict of interest. A conflict of interest is a set of circumstances that create a risk that your professional judgment or actions regarding the greater good will be unduly influenced by what you stand to gain from the decision. And that's a lot to try and undertake in one sentence. The essential component of conflicts of law legislation, the law seeks to prevent conflicts between private interests and your public duties, to foster integrity in public service, and to promote the public's trust and confidence in that service by placing restrictions on what municipal employees may do on their job after hours and even after leaving public service. And the question is, are you a municipal employee or a municipal public officer for purposes of conflict of law purposes? You do not have to be a full-time paid municipal employee to be considered a public municipal employee for conflict of interest purposes. Anyone performing services for a city or town or holding a municipal position, such as yourselves, whether paid or unpaid, including full-time and part-time municipal employees, elected officials, volunteers, and consultants, are considered under the municipal umbrella for conflicts of interest. What are some of the conflicts of interest that are addressed in municipal or in state statute? And for those of you that have state statutes, I am referring to Article 1, Chapter 5, Offenses Against Public Administration. What's important for you to understand from the very beginning is some definitions and how it's applicable to each of you in your jobs as a municipal official. Government includes any branch, subdivision, or agency of the state of Wyoming or any city, town, county, school district, or special school district. Governmental function includes any activity which a public servant is legally authorized to undertake on behalf of government. Harm means a loss, disadvantage, or injury, and pecuniary benefit is a benefit in the form of property. Public officer means a person who holds an office which is created or granted authority by the Constitution or the legislature who exercises a portion of sovereign power of the state. Public servant means any public officer, employee, or any person participating as a juror, witness, advisor, consultant, or otherwise performing governmental function. Now, the first component that's discussed under this section is bribery. And a person commits bribery if they offer, confer, or agree to confer any pecuniary benefit, testimonial, privilege, personal advantage upon a public servant for the public servant's vote, exercise of discretion or other action in their official capacity, or while a public servant, you solicit, accept, or agree to accept any pecuniary benefit, testimonial, privilege, or personal advantage upon an agreement or understanding that your vote or exercise of discretion or other action as a public servant will be thereby influenced. Bribery is a felony, punishable by imprisonment of not more than 10 years, a fine of not more than $5,000 or more. It's a pretty hefty criminal penalty for bribery. Gives you an indication of what the state legislature, they find that very serious, a very serious offense and allegation. The next component is compensation for past official behaviors, and that's Wyoming Statute 65103. A person commits an offense if they solicit, accept, or agree to accept any pecuniary benefit as compensation for having as a public servant given a decision or vote favorable to another, or for having otherwise exercised a discretion in his favor for having violated his statutory duties. For the purposes of this section, compensation does not include more acceptance of an offer of employment. This is a felony punishable by imprisonment of not more than 10 years, a fine of not more than $5,000, or both. Again, a very, very hefty criminal penalty for that. The next section, which is probably the section that many of you will work through through most of your term in office, is conflict of interest, and that's under Wyoming Statute 65106. And that states as follows: except as provided by subsection B, a public servant commits an offense if they request or receive any pecuniary benefit other than lawful compensation on any contract or for letting of any contract or making any appointment where the government employing or subject to the discretion or decisions of the public is concerned. So it's a pretty broad provision, and it includes any sort of pecuniary benefit outside of your normal compensation, including any public works contracts, municipal contracts, leases, any type of agreement or letting out of a contract or bid. I go into subsection B now. If any public servant discloses the nature and extent of his pecuniary interest to all parties concerned therewith, and does not participate during the consideration and vote thereon, and does not attempt to influence any of the parties, and does not act for the governing body with respect to the contracts or appointments, then the acts are not lawful under subsection A of this section. Subsection A of this section does not apply to the operation, administration, inspection, or performance of banking and deposit contracts or relationships after the selection of a depository. A violation of this subsection is a misdemeanor, punishable by a fine of not more than $5,000. So let's talk about that a little bit more and the process in which you declare conflict and how you note for the record that you have a potential conflict in this matter. If you have an actual or perceived conflict, I recommend you take the following steps. Number one, the actual or perceived conflict shall be disclosed at an open meeting or hearing of the governing body. So you should openly discuss or identify that you have a potential or actual conflict of interest. You should then consider whether or not you want to consider recusing yourself. And recusing yourself is removing yourself from all consideration and official vote on that matter. Now, the individual with the actual or perceived conflict shall decide whether to recuse him or herself, and moving forward, you want to make that in the beginning before you enter into any considerations of the matter. You also want to ensure that the minutes of that particular meeting or the written decision of that hearing or action shows that the above process was taken. And your minutes should know if you choose to leave during the consideration and vote, your minutes should actually reflect the time in which you recused yourself and excused yourself from the public meeting. And when you return, you should return after the final vote. But again, these are recommendations to ensure that you have absolutely no questions or concerns being addressed regarding that potential or actual conflict of interest. Now, the important thing to understand is in Wyoming, in small towns, conflicts of interest are inevitable. You're going to run across them throughout the term of your office, especially in the workings of small town government, but they should be avoided and we should try and prevent them the best we can. I should note that the presence of a conflict of interest does not necessarily mean that a public official may not continue to act in a particular situation. The deciding factor should always be whether the official is able to impartially, despite the presence of the conflict, act on behalf of the governing body. One important caveat above, and this is very specific to those smaller municipalities, a higher conflict of interest standard applies to the context of quasi-judicial decision-making. Now, quasi-judicial decision-making are decisions that are rendered in situations where the rights of a particular individual are at stake, including land use developments, variance requests, and the like. In those situations, the affected individual has the right to receive constitutional due process protections, which includes the right to an impartial decision maker. If a municipal official with a conflict of interest participates in a quasi-judicial process, a court may determine that the official was not an impartial decision maker and may vacate the decision and order the matter to be reconsidered without the participation of the conflicted member. What's important to note in that is that the process is put on hold. If you participate in an action and there is a perceived or actual conflict of interest in that matter, and the aggrieved party or the applicant alleges a potential or actual conflict of interest, they may appeal your decision, typically to the district court in your area. And once the notice of appeal is on record, all proceedings are suspended, meaning whatever action you have approved is on hold until after the district court has reviewed that appeal and determined whether or not you acted in an unbiased matter. In those instances, just based upon the delay in the process, the potential legal costs, and the time involved by staff and your legal counsel, it's always preferable if there is a perceived conflict for you to recuse yourself and not participate in that action item. Again, it's based largely upon you as the public official. You have to weigh that, and hopefully with the discussion of legal, weigh those options and determine whether or not you believe that you can act appropriately when that conflict has been disclosed. And the statement in most of the case law seems to indicate or favor that municipal officials should be more inclined to recuse themselves when they are participating in a quasi-judicial process. Now, for the city of Rollins, a quasi-judicial process or board would be our Planning and Zoning Commission or our Board of Adjustments, where both boards hear about property rights, take evidence, hear from all interested parties, and render a decision. And that decision ultimately does affect a citizen's property rights. In those instances, if the public official who may be serving on that commission, whether it be as an ex officio member or as a voting member, you should consider the potential downfalls of the appeal and having the matter being appealed to the district court with the delays. So if there's ever an interest, weigh on the side of recusal and do not participate in that decision. We've talked quite a bit about a number of things. I'd like to see, does anyone have any questions over anything we've discussed so far?
Hey, Amy.
Yes.
Justin. One question I get at the WAM office a lot, because we get a lot of phone calls from citizens, in particular municipalities, and they call us thinking that maybe we have some mediation ability with the individual municipalities when they have a grievance, which we don't, obviously, but they do call us and ask questions. But one that comes up a lot, and I think you touched on it a little bit, but is the mayor's brother mows the park, right? Like his mayor's brother's got a landscape company, and he's got the contract to take care of the park. Those sorts of things where it's like a family relationship to somebody that's on the council, maybe not the mayor, but one of the council people. How would you, because that does happen a lot in our smaller communities, how would you suggest that folks approach that if, and in a lot of cases, that may be the only person, that person with the family relationship may be the only person within reasonable geographic distance that provides that service. It's not that, now if there's competing interests, that's something different, but, say they're the only landscape company for 100 miles of that particular municipality. How would you suggest for these folks that they would, what lens would you have them sort of look through, look at that situation through to avoid having an issue with their constituents?
I would say it's always beneficial for the public official to disclose that conflict, particularly if it's an immediate family member, during a public meeting so that it's on record. Hopefully you have other members of the governing body that do not have a conflict of interest that will be able to preside and hear that discussion. But I would recommend in that instance, as far as approval of a contract with the immediate family member or employment, that public official recuse themselves, remove themselves from the discussion, and then return after a final vote has been made. It will save them on the family issue side, and it will save them from the public perception that there was something, that he had an interest or that he used his position to help or aid his family member, which is a great segue to nepotism. And this may be applicable for those smaller municipalities where you have family members that are employed by the city, and you have elected officials overseeing them or acting as the governing body. So nepotism: no public official, public member, or public employee shall advocate or cause the employment, appointment, promotion, transfer, or advancement of a family member to an office or position of the state, county, municipality, or school district. A public official, public member, or public employee shall not supervise, manage a family member who is in office or position of the state, county, municipality, or school district. A public official, public member, or public employee acting in their official duty, so you're acting as the mayor, you're acting as the vice mayor, or you're acting as a city council member, shall not participate in their official responsibility or capacity regarding a matter relating to the employment or discipline of a family member. So it's very clear that you should not have any involvement over their employment, their supervision, their advancement, or any disciplinary action of that family member. Additionally, in small towns, everyone seems to know everyone. Everyone is able to see the mayor at the coffee shop or see the mayor at the bank. And there's a fine line between small towns and notoriety and misuse of title and prestige in public office. In Wyoming Statute 913-103 states, no public official, public member, or public employee shall use their office or position for private benefit. Private benefit means the receipt by the public official, public member, or public employee of a gift resulting from that office. Now, this varies from state to state regarding gifts. Some states indicate a $50 limitation. Anything under $50 is not considered a gift. Some states identify that food and beverage are exempted and not included. So you would have to refer to your state statutes as they modify them and change them as time to time regarding gifts and gratuities. Again, the important thing to identify is the public's perception. And you want to, at all costs, try and avoid any perceptions where the public can indicate that you have a conflict of interest, that you received a bribe, or that you are somehow aiding another individual because of those gifts. So it becomes a little bit more tricky during the holidays when municipalities receive gifts or gift boxes from contractors, engineers, those types. It's a very, very fine line and a very slippery slope. So that's something that the governing body, together with your city administrator, should talk about. Again, the municipalities, we can be more restrictive. We cannot be least restrictive. So your starting point is always going to be the state statute. And what does the state statute indicate? And as long as you're being more restrictive, you can amend that or modify that under home rule to make it more restrictive to fit your municipality. Now, clearly, a decision like that may work well for the city of Cheyenne. It may not work so well for the town of Medicine Bow. And so while we all work together, it's important for you to understand that each municipality is unique. Each one of us has our own different set of circumstances and issues and concerns, and we can draft our ordinances specific to meet our individual needs. So you don't have to have an ordinance in place that mirrors the city of Casper, the city of Rawlins, the city of Cheyenne. So long as you are at least as restrictive as the state statute or more restrictive, you can engage in those discussions. And this misuse of office, the smaller municipalities seem to run across this more often. A mayor pops in and needs a quick photocopy, or a council member needs to fax something personal. Now, Wyoming Statute 913-105 states a public official, public member, or public employee shall not use public funds, time, personnel, facilities, or equipment for his private benefit or that of another unless the use is authorized by law. And as I stated, that gets a little bit more tricky on those smaller municipalities where you may not have access to that equipment. And I would say use your best judgment to try and avoid those instances the best you can. That's not to say that staff isn't there to assist you in your duties as a council member or to provide you city information or city communications. This is strictly where it's a private benefit for you. Now we're going to go into the official decisions and votes. This can be very, very problematic, especially in small towns where we all know each other, we're all friends, we have potential conflicts of interest. But as a governing body, as an elected official, you have to put your personal feelings, your personal bias, your personal prejudices aside, and your vote has to be unbiased and based upon the best interests of your ward, constituency, or city or town. And that is probably the most difficult position for most newly elected public officials is to understand that you may have very, very strong personal feelings on a subject matter and you vehemently object to it. The city of Rollins was engaged in something very similar regarding parking of trailers on streets. And we had those that were vehemently against allowing people to park trailers on streets, and those that were vehemently supportive of it, and everyone in between. And it was very difficult for a few of our council members because personally they may have felt one way or another, but they understood through the process that their opinions gave way to their constituents' opinions. So in those instances, they were able to put aside their personal beliefs and render a decision that they felt was best for their, after hearing from their constituents, they felt was best, and they put aside their personal opinions. And that's very difficult, especially in small towns, when you see the individual the next day, or you see the citizens the next day, and they're so upset because, hey, you were in this with me, you were supportive of this, why did you vote against it? Well, unfortunately, I had to listen to, my constituents' voice was loud or louder, and it was louder than my personal voice. Your personal voice should be put aside when you go into entering into a decision in government and deciding what's best for the city. Your number one priority in that instance is what's best for your city or town, and then work your way back down. So Wyoming statute 913-106 states a public official shall not make an official decision or vote on any official decision if the public official, public member, has a personal or private interest in the matter. In determining whether they have a personal or private interest in the matter, the public official shall recognize the importance of their right to represent their constituency, which is what we just discussed, and shall abstain from voting only in clear cases of a personal or private interest as defined in the subsection. Now, a public official shall not vote to give money or any direct financial benefit to himself for tax reductions affecting the general purpose, except for tax reductions affecting the general public. For this purpose, a personal or private interest is defined as follows. With respect to the public official, an interest which is direct and immediate as opposed to speculative and remote. I'm employed by, or you own an oil company, and there is a bid before the city of Rollins for a street project. Your company is supplying the oil for that street project. You will receive that, if you receive that bid, you will see, and they will purchase that oil from you. That is a direct and immediate interest. Speculative and remote is some instance where you own property in the city that's undeveloped, that does not have infrastructure to it. There's no water, there's no sewer, there's no electricity, there's no gas. And what comes before you is a rezone of that property together with half the town, let's say. In that instance, it would be speculative for you to have that you will show a benefit of that. It's not limited to your parcel. You don't have it for sale. You don't have a willing buyer. It's not under a development agreement, those types of things. In those instances, I would say that would be speculative and remote. Number two is an interest that provides the public official a greater benefit or a lesser detriment than it does for a large or substantial group or class of persons who are similarly situated. So by voting on this, are you receiving a special benefit that's not available to other residents in your community or available to your neighbors? If so, that's where you need to take this into consideration. A public official described by section A of the section shall, not may. Shall means you do not have any discretion. You absolutely have to abide by what they're saying. There is no discretion on your part versus may. May, there's some discretion. Shall abstain from voting on the decision and from making any official decision in the matter. The public official's abstention from voting must be recorded in the government's official records. And why is that important for it to be noted in the government's official records? If 5 years from now you're challenged by a developer or you're challenged by another bidder on whether or not you participated in approval of that bid, the official minutes of your governing body, which are historically kept, are going to be available for you and the governing body as proof that you adhere to the government ethics statutes and your own policies and procedures regarding codes and ethics. So it's very important that your official record detail that abstention, that recusal, and it's not enough for you just to do it in the public hearing. You need to make sure your city clerks are recording that in your official minutes that you approve. Does anyone have any questions regarding official decisions and votes?
You know, one thing I was going to point out, Amy, going back to the kind of the gifts discussion. So some of you, depending on where you're at in the state and how close you follow the newspaper, can recall maybe not this summer, but the summer past. Obviously, this last summer it wasn't a going concern, but we had a situation where one of the mayors down here in the southeast corner caused a lot of consternation with some of the members of her council, and there was some pushback over use of something. So wherein is it's pretty cut and dry when you're talking about tangible, something physically tangible, being given something like Amy said, a gift basket or those kinds of things from an engineering firm. Or in this particular case, there was an automotive dealership that wanted to give this particular elected official use of a vehicle for the duration of a festival week, basically here in one of the cities. Some of the members of the council brought up the fact that technically is a gift. Well, how do you define monetary value on use of something? Well, then that kind of falls back, and the argument was, well, what would it cost to rent that truck from Enterprise or another from a car rental agency for a week? Well, that certainly exceeds the gift threshold in state statute, never mind what it might be in the particular municipality. So be careful in situations like that, because sometimes it's, somebody might offer you the use of something, and that can still be, the monetary value of that could still be considered in excess of those gift limits pretty quickly, usually, especially in the case of equipment or an automobile or those sorts of things, or maybe even a room at a hotel chain or those kinds of things too. So one thing I was going to ask you, Amy, just to get your thoughts too. So we did kind of just a fun thing that we did in our weekly newsletters last year. We did some trivia where we did $10. It was a $10 gift card if people got those questions right. And I had an official from one city that played every single week. And he finally won, because we did it as a little bit of a different deal. Everybody who got the right answer, then we entered them in a drawing. I sent that gift card to him and I said, did you get your gift card? He's like, yeah, but he happened to be a city administrator. Basically, and I don't remember exactly how he did it, but he didn't want to keep the gift card. He didn't want, even in that case, he was worried about the ethics of accepting that gift card as a municipal official. And I forget how he he remedied that. They had some kind of a community pot thing or something, basically in the town hall, where everybody then in the town hall could be eligible to get it, sort of a thing. But in that particular instance, I mean, what do you, or say even maybe going back to the gift baskets or something, is it more acceptable if you receive something like that, that if it's, you know, if it, you know, say you set that on the break room table at City Hall or something along that line, is that more or less acceptable in the eyes of the law?
You know, I think there's been a few cases that have presented themselves. And I think what we mostly see in city government or local government in Wyoming is something in the middle. We don't see the really grand gestures or gratuities that maybe you would see in an urban setting. And we typically don't think twice about those little picking up someone's coffee at the coffee shop or buying someone a donut, or your public official a donut at the donut shop. Most of the things that we see in Wyoming are run-of-the-mill middle items, just as I stated with our municipality. Those gift baskets during the holiday season, during the City of Rawlins 150th anniversary, we received items from other municipalities, items from local vendors and contractors. And during my tenure as city attorney, we've had city administrators who have taken the approach that it's absolutely a slippery slope, and we're not going to accept anything. We've also had city administrators who have identified that based upon, you know, the value, based upon that it was shared across the municipality, that there wasn't a current pending bid or open agreement or contract, that it was permissible. I would say go to your city or town or attorney and seek their advice. It may be more fact specific, depending on circumstances that we're unaware of, but that's where you would tell your city or town attorney everything that you know and what's currently going on. Obviously, if you have a current open bid, that's going to be suspect. To receive a gift basket from an engineering firm with an open bid, I would say, I would recommend that we would not accept that. What I would do is reach out to the contractor, vendor, or developer and thank them for the wonderful gift and ask them if you can donate that to a local church, charity, or nonprofit in your area, so that it is going to use and that they understand that you appreciate it. However, in this instance, you can't have that perceived conflict in that situation. And it's going to be a little bit more difficult in those smaller towns, smaller municipalities. Just being familiar with Carbon County, you know, town of Medicine Bow, town of Hannah, those types where everyone knows everyone and you help your neighbors, and you're more likely to have the business down the road offer to bring in dinner for public works because they've been out plowing snow all night, or they know that your public works has been working on water breaks all day. They're going to bring over some donuts from their business and the like. I would say use your best discretion and judgment. It's municipalities, more and more we work within that gray area and trying to do what's best for our communities, not violate the law, but also recognize that we do live in small communities and our constituents want to contribute and help and show their appreciation for municipal workers. So there isn't a hard and fast rule regarding that, but I would say use your best judgment, and in questions where you are not sure, reach out to your town or city attorney and they can give you some sound recommendations for you to rely on. So along those lines, municipal employees should be very cautious about receiving gifts or gratuities, especially given to influence their official actions or because of their official position. That's where we went into that open bid process. If you have an open bid or a contract, or there's a pending variance request, you shouldn't accept any gifts or gratuities in that instance from that individual. Accepting a gift intended to reward past official action or to bring about future official action is illegal. Accepting a gift given to you because of the municipal position you hold is also illegal. If you receive a gift to the mayor, newly elected mayor, it's out of the blue. You do not have any family or familial relationship with them or personal relationship, but it is a pretty substantial gift. Chances are that's an attempt to influence you in your future actions in the matter, and you should not accept that gift or gratuity. Again, it's going to be fact specific based upon the circumstances of the situation, and it's necessarily just large monetary gifts or gratuities. A series of smaller gifts and gratuities over time could, as a pattern, show or evidence some wrongdoing or intent. So be cautious of that as well, where every time you're in a coffee shop and there's a matter regarding zoning in the industrial area, and this gentleman who has property in the industrial area always picks up or tries to pick up your coffee or your breakfast. In those instances where you can show over a period of time that there is a pattern, that would be something that I would avoid, even in small municipalities as well. So you have to be conscientious of what you do in everyday life, but use your best judgment and common sense. And if it doesn't feel right to you internally, chances are, going back to our duck analogy, chances are it may not be illegal according to statute, but it most likely is unethical, because your inner voice is going to tell you something just doesn't seem right. If it doesn't seem right, it probably isn't right, and you should probably avoid that situation. I have a few examples. And it may not go as well because you're over the video, but I always find that it's helpful to provide some examples to place it into context of what you may or may not see, and so that you can apply what you've read, because reading state statutes will put you to sleep more times than not. So that's not my intent. I want to give you the information, but I also want you to walk away today feeling like you've picked up something applicable, something that you can carry on, or at least give you the idea, I need to research this more, or I need to talk to our city attorney or our town attorney, something to just second guess what you're doing to avoid those missteps. So a full-time city employee writes a novel on their work time using their office computer and directing their assistant to proofread the draft. Is there anyone who thinks that that is permissible or that's a good idea? A city councilor directs subordinates to drive the city council's wife to and from the grocery store during winter conditions. Does anyone believe that that's appropriate use of city manpower? I agree. A mayor avoids a speeding ticket by asking the police officer who stops him, "Do you know who I am?" and shows his municipal ID. Does anyone think that that's a good idea or a good position to place either the mayor or the police officer in? You're correct. Now, for those of you that have affordable housing committees or affordable housing subcommittees, a member of a town affordable housing committee is also the director of a nonprofit housing corporation. The nonprofit makes an application to the committee, and the affordable housing committee member participates in the discussion. Does anyone think that that's favorable or that should be undertaken? They should not participate in that, as we previously discussed. Any potential or perceived conflict of interest, you should identify the conflict of interest and determine whether or not you will recuse yourself. If you recuse yourself, you should do that at the beginning of the conversation, the beginning of the consideration, and not return until after a decision has been made, and ensuring that your official minutes notate that conflict of interest.
Amy, can I clarify that?
Yeah, absolutely.
Because I have observed legislators and a town council member here participate in debate and then recuse from the vote. And I just want to, that feels terrible to me, but I just want to clarify, is that like, it's best practice to recuse from the debate? I'm sorry, it's best practice to recuse from the debate, or is it the standard that you have to recuse from the debate? And if you don't, that's a conflict.
So I would say it's, I would say if it's not monetary and it's an actual or perceived conflict of interest, the governing member or public official has an absolute duty to advise the governing body when that action's brought before them of the potential or perceived conflict of interest. So you disclose it to the public as a whole during the meeting. And it may require you to give additional information. It may require you to advise why you believe there's a potential or perceived conflict of interest. And hopefully the official or governing body member has considered this and has determined that based upon all the circumstances available to them, that they believe they should recuse themselves. However, if they determine that they are not going to recuse themselves, they should indicate for their benefit on the record why they are moving forward and not recusing themselves, so that you have a record. If it's ever challenged to come back, you knew the facts or the reasoning behind that, why that governing body member chose to move forward, even with a perceived or actual conflict of interest. And obviously, an actual conflict of interest is going to be more difficult for them to defend against versus an actual or perceived. But as a governing body member, any actual or any perceived conflict also that from the beginning places you, the governing body, and the city as a whole in a potentially difficult light. And we should try and avoid those as best we can. So in my practice at the City of Rollins, my recommendation is typically, when in doubt, recuse yourself. And that recusal is from the beginning of the conversation, because you do not want any allegations that you attempted to influence the other members of the governing body. It's not just the vote that matters, it's the consideration and the influence that that member may or may not have during the consideration. Because I think we all know, as a governing body, your decisions evolved during that public hearing, that public meeting, and all the information you're receiving at that time. And that could include some biased information or information that's steered to drive you to a certain situation or a certain vote. So it's always best, when there are potential conflicts of interest or actual conflicts of interest, for that member to disclose it, to recuse themselves, and to leave. Our members we request them to physically leave the room or the meeting until that vote is rendered, and then they come back in. I know a majority of the municipalities do not do that. They simply recuse themselves and go and either sit at their table or go into the public audience section and then go up. Again, that's going to be driven largely by each municipality and how you want to best address those potential conflicts of interest, and how important it is for your citizenry to have those policies in place for you. But I would say your best approach is always going to be to consider creating policies and procedures, and that will eliminate each of the governing body members from having to police each other in those meetings and create a difficult situation.
Right.
But I hope that helps. Do you have further questions?
That was really great. No, that was good elaboration. Thank you. I'm sitting here thinking, gosh, personally, yeah, I would like recuse from the debate and walk out of the room, and that feels really good to me. But what you just spelled out is helpful too, of like, what's my role if I'm watching a peer not do that or do that? And I like the reliance on policies and procedures to start, but then you might have to, we might
hi. Well, and especially if you have a town attorney or a city attorney that's at your meetings, rely on them. Essentially, you want as good of a relationship with the governing body as you can. You're going to have those disagreements on issues, and it's going to be right or left and very tenacious, but on situations involving basic conflicts of law or conflicts of interest and bias and prejudice, it should be handled through your policies and procedures. And then your city or town attorney should be the, lack of a better word, you're heavy to guide them, so that each of you is not in a position where you feel as though you have to, or you should be policing a fellow council member. So I would strongly recommend, if you do not have conflicts of interest policies and procedures in place, that you consider that, and reach out to other municipalities that have them, just to give you a reference or a starting point. I would say that is the biggest benefit of WAM, is the amount of collaboration that I receive as a city attorney, being able to find drafts, or maybe there's a nuance in the law that I haven't dealt with, but the city of Casper has. I can reach out to their city attorney, and everyone is very open to sharing and providing as much information. And I would say, as new council members, I know that WAM's trying their hardest to get us together again for our annual convention. That is probably the single best networking tool for you, is to reach out to municipalities and make those connections, so that when you have an issue, sorry, my screen is, sorry, my screen is, sorry, I think we're good now. Is the best opportunity for you to reach out to others who have seen it, saw it, done it, and can give you some advice. It may not be 100% on point, but at least it gives you a starting point. And I would say that's across the board. As new council members, you're just struggling to understand what your duties and rights and responsibilities are. I would say don't stress yourself out with trying to reinvent the wheel. Chances are, if another municipality hasn't seen it or done it, they're going to be able to provide you with someone who has seen it or done it. And don't be afraid to reach out. Again, that would be my central issue to you. Now, as a city attorney for the city of Rollins, and if you have a city or town attorney, I need their permission to share documents or provide you with that information. But typically it's as simple as you reaching out to your town or city attorney and saying, Amy Bach presented something on conflicts and ethics, and I would like to see if she has a policy on that. Or Amy Bach presented on dangerous buildings, and she has all the forms from beginning to end. I think it would be beneficial for us to review them. And chances are your city or town is going to give me a call and say, please talk to my council member and provide her with this information, or forward it to me and I'll forward it to them. So I hope that helps a little bit.
Yeah, quite a bit. Thank you so much.
You're very welcome.
Hey, Amy, there's a question in the chat from Eric. Is it ever enough to just abstain from the vote?
So I would say, as the conflicts become more apparent and more serious, I think you have to rise to there's a greater degree of notice and removing yourself from those situations completely. If it's involving a development and the city council as a whole is scheduled to do a site tour, you should not participate in any manner in that site tour. Any communications involving that development, I would say tell all of your governing body members, your staff, and the outside developer that you do not want to participate, you do not want to be included, you don't want to receive any communications involving XYZ development. So I think in addition to recusing yourself, you do have to take those extra steps to avoid communication, to avoid participating in any deliberations or information or fact finding. The City of Rollins typically will have a workshop. And I would say, even though in the workshop you do not take official action because it's not during a published meeting, I would recuse myself from all discussions in that workshop as well.
Thanks, Amy. I also, real quick, I looked up offline. So the state cap as of right now on gifts is $250. That came up a bunch during the during that conversation about that truck use issue that we had here. So again, I think that falls back, or that's kind of a great illustration of your, you know, what's the legal standard and what's the ethical standard. $250 is actually quite a bit of money for a gift. So I mean, if you as an elected official say, you know, somebody brought you a very nice, you know, a very nice bottle of wine, or, you know, or something along those lines, I mean, up to $250, why, you know, maybe that $240 bottle of wine or liquor or something at the holidays might be within the limits of the law. I think for most folks, it would kind of hit us as, you know, being out of bounds on the ethical front. So again, that's kind of the legal threshold versus the ethical threshold.
Oh, absolutely. And it's really going to be fact specific and based upon all the current factors of that situation in that time. Something that may not be, you may not raise, you know, an eyebrow about today, may be problematic 3 months from now when there's a pending development permit, or there's a variance request or a rezone request, or there's a large bid that's outstanding. And then all of a sudden you know, your elected officials receive holiday hams from this developer, or you receive something, while it wouldn't hit the $250 threshold, boy, I would not want to accept that gift and have that, even the mere appearance that there was some influence on us awarding a bid or approving a variance or a development. I would just say, just follow, stick as close to that smell test as you can. If it just doesn't smell right, it's probably not right, and don't follow through. And again, yes, legal standard is the bare minimum. It is not, while you can't be prosecuted for anything, you know, below that, you do have to be conscientious about, you know, as a person, is this ethically and morally okay? Is this something that I can look myself in the mirror tomorrow? Yes, it's under the $250 mark, but boy, I just don't think I'll be able to look myself in the mirror tomorrow. In those instances, like I said, it's always best to reach out to the person, the gifter, and identify, thank you, I sincerely appreciate the gift. However, I just don't feel comfortable accepting it. Do you have any objections to me donating it to our senior services center or to our Boys and Girls Club? And those types of things is the way we've been able to address it, where we're not just refusing it and creating some bad blood or some issues with the contractor or vendor or developer, but instead we're turning it into another positive where more individuals would receive benefit from it, but we don't receive the direct benefit as a municipality. So it's 4:10. I have reviewed or compiled and discussed all the items that I have on my list. At this time, I would like to open it up to any potential questions, even things that I didn't discuss hypotheticals or anything to assist you or concerns that you may have regarding ethics and conflicts of interest, and something that, boy, you've thought of, but you just don't know how you would move forward. Does anyone have any questions that I could help address?
Amy,
Yes, sir.
a question that came up when I first got on the council was, I'm also a member of an advisory board. And I just I'm not for sure that I really felt that there was a conflict with my being on an advisory board and on the council. I just was wondering what your thoughts on that might be.
Yeah, with the city of Rollins had an issue regarding two of our council members who previously were appointed to city boards before they were council members. One of them was, we had a county official that was appointed to our Police Civil Service Commission. And so he had been serving for a number of years. And then we had a council member who was actually the chairman of a joint powers board, our airport board. And so there was great discussion about, there were those who were challenging them being able to be on both. I rendered an opinion and our county attorney rendered an opinion just merely based upon the specific boards that they served on and their positions both as a county commissioner and as a city council member. We determined that as a whole, there wasn't a potential per se conflict of interest from them serving on that, but that there could be issues or action items that may be presented to them where it would present a conflict of interest. And in those instances, they would simply go through those steps of identifying and disclosing the conflict of interest, either recusing themselves or putting on the record why they are not recusing themselves and moving forward. And as I stated, that request came from outside sources. So I think it would depend on what advisory board you're on and what your official role is. Now, if you were previously on the Board of Adjustments or a planning board and you were a voting member and you weren't a council representative, that potentially could be. In our instances, where we had a golf course advisory member, we had a airport joint powers board member. Most of their action items would be related to their advisory board and not relative to their service as a council member. Now, if they came to the council as a joint powers board for funding, that's where the chairman of that board would have to identify that he's the chairman of the joint powers board and he would recuse himself from the action of funding the airport board. If that helps, does that answer your question?
I went a long ways towards it. The board is the recreation board and my position is vice chairman. Yes, this is into my full second term on that board before I was ever elected to the council. And
it's something that you have an interest in and you want to continue to serve in that role? Correct.
But if it comes down to that, yeah, the biggest part was the nice lady from Lander mentioned that stepping all the way out of the room, there's information that you can have, but unfortunately, as you pointed out, it may or may not influence your other council members. So yeah, you got to step out.
That's what I would strongly recommend. If you have facts or circumstances from your position on the advisory board above and beyond what your governing body has or should have, in those instances, yeah, you need to absolutely be cautious and try and limit your involvement, recuse yourself and remove yourself. But as a whole, I understand the importance of these advisory boards and commissions, and the city of Rollins is no different. We struggle to maintain memberships and quorums, and when you find a member that really feels committed to that advisory board or planning or commission, you want to try and include that involvement and have their goodwill moving forward. So,
Well, probably one of the reasons why I was most concerned about stepping completely out of the room is that a couple years ago, we had a city administrator that completely misrepresented what that advisory board had said and what is recommending to the council. He put his own agenda forward and the numbers got totally skewed. And it's something I don't want to ever see happen again.
sure.
Because that to me was also wrong.
We've had those instances in the past here at the city, and that's why I cautioned about leaving the room. You have to have a great deal of trust and respect for those that are presenting and that are officiating the meeting itself, to ensure that they are providing the governing body with accurate information. And in those instances where you feel that you have an issue, you're worried about misrepresentation, or you're worried that there will be some undue influence, as long as you remove yourself, I would recommend removing yourself from your position on the council, wherever you sit, and going to a position out in the public, so you are able to hear and see everything that is going on, and so you're able to attribute or verify that the information that's being provided is true and accurate. But if it's not, the issue comes up that you really don't want to impart yourself into that. You have to be really cautious, because you don't want to be accused of you influencing the decision after you've declared a conflict of interest. And for some people, it's really difficult for them to remain in the room and to hear something that they disagree with, or that may not be as accurate, or you may have different wording. You would have a difficult time not going up to the podium and correcting that. And so that's the cautionary tale, I would say, with you remaining in the room, is that while you have the information and you can affirm that it may not be 100% factual, or there may be misrepresentations, you also want to ensure that you continue to not be in a position where you could be argued as influencing the governing body, whereas you would state, hey, this didn't occur, or during the last meeting of the advisory board, we discussed X, Y, and Z, but we did not discuss T. And so I would be very cautious, but I absolutely understand your concerns regarding exiting the room and having misinformation being provided in that instance. You would have to rely heavily on your city administrator or city staff in that instance. And if you have an indication that you think there will be some misrepresentations, that's what I would recommend. You reach out to your town or city attorney beforehand and identify that this is the past behavior that you've witnessed, and moving forward, you have concerns that it may reoccur on this night. And that way your town or city attorney is more cautious and conscientious of what's occurring, and they have a better eye out for what's for your concerns, and that they're in that position to state, this matter should be, I would recommend that we postpone this matter so that they can provide the correct facts or the most cogent facts for the governing body. Because at the end of the day, the governing body is entitled to receive the most information so that they can make an informed decision. And misinformation does not aid in that purpose.
Hey, Amy.
Okay, thank you very much.
You're very welcome.
Would you think in a situation like that, because I could see it, so there's multiple members on that board or that advisory council. Would you think it would be a best practice of a person that found themselves in that situation? I think the propensity would be, because everybody, you know, everybody respects everybody else's time and those kinds of things. If you know something's coming up, say about the golf course or whatever, and you're on that golf course advisory council, you know, maybe your first inclination would be to tell everybody else on the board, well, I'm going to be there anyway. I'm going to be, you know, I have to be at the council meeting anyway, whereas maybe it would be, would you think that it would be more of a best practice to always ensure that there was somebody else from that advisory board, if they knew that was on the agenda, you know, items about that on the agenda, to be there to represent those facts, as opposed to you saying, well, I'll be there anyway, don't worry about it. And, you know, basically removing yourself from being the official representative, you know, in the council capacity. If you're going to have to recuse yourself anyway, you can't then, like you say, it's problematic to step in and, you know, get into a factual argument or whatever. Would you just suggest it be best practice that, you know, say if Dale knew something was coming up, you know, from the Parks and Recreation on the agenda, that he would just, you know, that he would just make sure that somebody else from that particular board knew about it and hopefully would be able to attend the meeting?
Yeah, I think that's always preferable. If you know, when you're serving on two boards, you really shouldn't have two masters. You should be answerable to your constituents and be there to represent them, which would be in the city council role. However, you do have a fiduciary duty to both the city council or town council and the board you're serving on. But how you can address those conflicting issues is if you have problems or issues involving misrepresentation, or if key facts are being omitted from the governing body. We have addressed that where we have the boards make written recommendations and findings, and the board as a whole will vote on those, so that you at least know when you're leaving your advisory board that this information is being transmitted to the council with this recommendation. And then you're able to, at the advisory level, add or subtract key information as you see fit that's important, that you feel is important to the governing body, so that you know that moving forward, all the information that you think is important is being conveyed, and we're not omitting anything that's key or controversial. Because as we know, sometimes we want to paint a rosy picture as it goes to council, and we're not giving them the cons as much as the pros, and it slants their decision. But we owe it to the council to give them the good, the bad, and the ugly. This is staff's recommendation. This is the commission's recommendation, and here's an alternative. I think that's always preferable for the governing bodies, because when you're on the hot seat and you're just trying to decide, you know, what is best for the city, what is best for the town, it's helpful for you to understand that this is the staff's position, this is the commission's position, and then here's an alternative if neither of those sounds right, because we're in a better position as staff and the advisory board to think about these issues before it comes to you, versus you hearing about it one night and you're being forced to make a decision. And so I would say address the misrepresentations by considering written findings or written recommendations to your governing body, and then having your spokesperson, usually your chairman, available to the council to present it or answer questions. But essentially, your written recommendations and findings are going to serve as your record to the city council. And then, of course, if they have questions and those questions you need additional information, they can always postpone that matter and send it back down to the commission for further discussion. What I would say is, as a governing body, if you do not feel you have the adequate facts to render a decision or to defend your decision, it's always preferable for you to take a deep breath and take a step back and get those facts. It's just going to provide you better defense, and it's going to provide better buy-in from your community that you vetted it fully and that you've explored the ins, the outs, and the possible alternatives.
Thank you.
You're very welcome.
One other One other question I had, Amy, that I had written down, knew, and I was going to have a chance to pick your brain today. And especially for new council members, I get calls from newer council members a lot of the time. Say you've got say you have a disagreement in the council, or there's basically there's maybe some concern about a legality of something, say in this particular in the framework of what we're talking about today. Say you felt like there was an ethical breach, maybe something even arising to the point of bribery, those kinds of things. My advice to folks is always just what you said. We'll talk to your town or city attorney, as kind of your first line of defense. But I've gotten the rebuttal a lot of times. Well, the city or town attorney is friends with, person in question X, because of those close personal relationships that we have, because of the small town dynamic. Who then would you have somebody to turn to, in a situation like that? I mean, obviously, if it's a law enforcement concern, maybe that's a little more obvious, but, is there another line of defense if kind of the attorney is not really there for you?
Yeah, so those are particularly difficult in small towns where you have personal relationships with others, and you have to be very, very careful as a city or town attorney to try and limit that the best you can. But with that said, we're humans, and we do have a private life, and we do like to have our friends and have those relationships. It does become problematic in that instance where a city council member or a city staff knows that you're friends with the chief of police, or knows that you're friends with the fire chief, or knows that you're really good friends with, whoever it may be. It does put you in that situation. You always should be very cautious of your relationships within the city, and maintain positive relationships, but maybe not personal relationships. Now, with that said, there are some relationships that you've had since you were a child, before you went to law school, before they worked for the city, those types of things where there really isn't a whole lot that you can do to limit that conflict of interest. And what I would recommend is if it's a staff member, reach out to the city manager or city administrator. If it's a situation where it's a council member and the council member's concerned with the city attorney, they should reach out to the city manager. Ultimately, if it's anything involving criminal misconduct, anything involving financial or embezzlement, those types of things, you're very right. You can reach out to the county sheriffs in your town and municipality. And I would not overlook the Department of Criminal Investigations in that situation. The important thing when reaching out to law enforcement is they should be able to provide you, even if it's outside their jurisdiction, they should be able to guide you and provide you with another resource of who you can contact in this instance. So if the sheriff's department's indicating it's not a criminal matter that they have jurisdiction over, they should be able to at least provide you with another entity or agency that you can come in contact with. And then lastly, I would say, don't be afraid to reach out above the municipality or above the city. If it's something that goes to the heart of the public's trust and confidence in what we're doing, you absolutely need to report it and reach out until you find someone that hears you and that will at least investigate it thoroughly and provide a detailed investigation of their findings, so that you have that to know that you did what you were supposed to do. You fulfilled your fiduciary duty to the city or town. You've reported it. You've ensured that the reporting agency is investigating it. And once they undertake their investigation, other than them seeking to interview you regarding direct involvement or what information you have, you've essentially fulfilled your duties by getting that to an investigative agency. And now they have the duty to investigate it thoroughly and provide findings of their investigation. And if it is determined that it was criminal in nature, provide that to the county attorney in that jurisdiction for potential charges.
Thanks.
Mhm. You're very welcome. I'm near the end of my notes. What I wanted to suggest to this group, and I think it's, once again, I'm very supportive of the creation of this program, and but moving forward, I would recommend that each of you, as you go through this boot camp and as you go through your first term in office, if you are seeing an issue that you just don't understand, or if you feel like there's a change in the state law and you feel one way or another about it, I would say please write that down and share that information with WAM and Justin. They do a phenomenal job of making sure all of our trainings are on point and relevant. And if there's a current issue plaguing your municipality, chances are you're not alone, and it's something that someone else can benefit from. So please, as you're going through this, don't be afraid to request additional trainings outside of what's being presented in this program.
I don't have any other questions in the chat. Does anybody else have any other questions? Feel free to unmute if you do. I don't see any. That being said, so next week we'll have kind of a dual session. Joe's going to lead off, and then we have the Wyoming Business Council is going to be here to kind of explain some of their programs. If you're not familiar, Business Council was created and is funded by the state, really to be an organization that drives economic development and diversification and in across the state in our communities. They offer a lot of different programs. They also are kind of the first vetting line in the SLIB process for mineral royalty grant loans and grants, as well as what they call BRC, or Business Ready Community Loans and Grants. So especially if your town's looking to bring new industry in, or help a business or entity that might already be in your town expand, those kinds of things. They're an excellent resource. They have regional managers all over the state, and so they're going to have some of their statewide representatives here to talk about their programs. The week after that, Joe will touch again on one of his core topics, and then we'll be on to we'll have representatives from the Wyoming Association of Municipal Clerks and Treasurers. Penny Robbins, their president, has been sitting in on these sessions too. So she'll be here, as well as some of the other representatives from their board of directors, to explain not only what WAMCAT is, but also kind of what your clerks and treasurers do, what their responsibilities are across your municipality, and how they can help you as well in your newly elected role. And then the very last week, Joe will finish up on his core class work. And then I've got Dustin Blyzeffer, who is a writer for WyoFile, a freelance journalist here in the state, is going to do a presentation for us on media relations, how to deal with media members, and how to relate with those folks. So that's kind of what we've got coming up over the next 3 weeks. I hope everybody has a good rest of the afternoon. I hope it's maybe not as cold where you are as it is where I am, because it's miserable outside today. But we'll hope for a little more sunshine over the weekend. Maybe it's probably optimistic, but I thank you all again for taking the time to be here this afternoon, and we'll look forward to seeing you again on Friday.
Thank you, Justin.
You bet. Thanks again, Amy. I appreciate it.